Hi, this is Mark Sokolow. I'm an attorney in Texas. I've been an attorney for over 30 years, and I'm presently teaching business law at San Jacinto College. Prior to that, I taught political science at Lamar State College and at Lamar University. Today, we're going to talk about the Dodd Frank Act, and we're going to go over various documents as well as a Fifth Circuit opinion. The basic premise that you need to obtain from watching this video is that if you violate securities regulations, it does give people that report those violations or perceived violations to SEC, it makes them a protective class. In other words, if you fire them and they can show that they reported an SEC or securities violations to the Securities and Exchange Commission, then they can recover. So it does give them a cause of action. Secondly, the Securities and Exchange Commission is offering a bounty program where people report securities violations to the SEC, and if it's over $1 million in sanctions are levied, then that person can get a percentage of that amount. And we're going to go over at least one award and discuss it. I hope you enjoy the video. And of course, this video is designed for my students in the business law class. Thank you. Hi, again, this is Mark Sokolow. This is Section 78U of Title 15. And what you see here, this is a federal law that provides protections for whistleblowers who report securities violations. Now, in this case, they're providing basically a bounty, and they expect people to obtain original information from a whistleblower, and which result in monetary sanctions against a company. So let's kind of go through this. And you can find this this law by going to the Thomas website, which is a Library of Congress website. Here they discuss how they're going to give out awards. It ranges from not less than 10% to not more than 30% of the sanctions amount. When they decide how much award they're going to give, the significance of the information provided by the whistleblower to the success of the judicial or administrative action, the degree of assistance provided by the whistleblower, the programmatic interest of the Commission in deterring violations, and such other relevant factors as the Commission may determine. And then you go to this section right here, protection of whistleblowers. No employer may discharge, demote, suspend, threaten, harass, directly or indirectly, or any other manner, discriminate against a whistleblower in the terms and conditions of employment because of any lawful act done by the whistleblower. One, in providing information to the Commission in accordance with this section. So if you report something to the Securities and Exchange Commission, and if someone demotes you, suspends you, harasses you, then you can file a lawsuit under this act against that company. Two, in initiating, testifying in, or assisting in any investigation or judicial or administrative action of the Commission based upon or related to such information. So the first part right here is providing information to the Commission. The second part is assisting the Commission. And the third part, in making disclosures that are required or protected under the Sarbanes-Oxley Act of 2002. Any law, rule, or regulation subject to the jurisdiction of the Commission. Any individual who alleges discharge or other discrimination may bring an action under this subsection in the appropriate district court of the United States, so you file an action in district court. There's a 6-year statute of limitations. Do not be brought more than 6 years after the date in which the violation or subparagraph occurred, or more than 3 years after the date when facts material to the right of action are known or reasonably should have been known by the employee alleging a violation. Then you get down to this, the relief. In other words, when you sue, what do you get? You can get reinstatement to your position, 2 times the amount of back pay otherwise owed to the individual, and compensation for litigation costs, expert witness fees, and reasonable attorney's fees. And, except as provided under the regulations, the Commission shall not disclose any information, including information provided by a whistleblower, which can reasonably be expected to reveal the identity of a whistleblower, except in accordance with this Act. Now the Securities and Exchange, here's a document from the Securities and Exchange Commission, release number 34-64545, where they're implementing provisions of the Whistleblower Act, and they're basically adopting rules and forms. And these have been effective since August 2011. They go into what do they consider to be the definition of a whistleblower, the payment of awards, information that leads to successful enforcement, monetary sanctions. It goes into that Section 922 of Dodd Frank, added the new Section 21F entitled Securities Whistleblower Incentives and Protections. And what this does, it pays awards subject to certain limitations that lead to the successful enforcement of action brought by the Commission that results in monetary sanctions exceeding $1 million. In other words, if you report something and it causes the Securities and Exchange Company to go after the company, and there's monetary sanctions of over $1 million, then you might get a piece of that, piece of the action or a bounty. This is important. After considering different viewpoints of whether or not you should first report a violation to the company, they say that they've determined not to include a requirement that whistleblowers report violations internally. But they may consider, that we made additional changes to the rules to further incentivize whistleblowers to utilize their company's internal compliance and reporting systems when appropriate. One, they're saying that if a whistleblower voluntarily participated in a company's internal compliance and reporting system, that could be a factor that can increase the amount of the award. And second, that if a whistleblower interferes with the internal compliance and reporting system of a company, that can be a factor to decrease the award. They have adopted a form TCR that a whistleblower can use to report a violation. This is a press release from the Securities and Exchange Commission where they're reporting their first whistleblower award on August, and it's dated August 21st, 2012. A whistleblower who helped the Securities and Exchange Commission stop a multi-million-dollar fraud will receive nearly $50,000, the first payout from the new program, to reward people who provide evidence of securities fraud. The award represented 30% of the amount collected in an Securities and Exchange enforcement action. So they basically were able to obtain roughly $150,000, roughly that amount, and the whistleblower obtained $50,000 for reporting it. The award recipient, who desired not to be identified, provided documents and other significant information that allowed the SEC investigation to move at an accelerated pace and prevent the fraud from ensnaring additional victims. The whistleblower's assistance led to a court order ordering more than $1 million in sanctions of which $150,000 has been collected thus far. The court is considering whether to issue a final judgment against other defendants in the matter. Any increase in the sanctions ordered and collected will increase payments to the whistleblower. And then goes that the 2010 Dodd Frank Act authorized the whistleblower program to reward individuals who offer high-quality original information that leads to an SEC enforcement action in which more than $1 million in sanctions is ordered. Awards can range from 10% to 30% of the amounts collected. Now, this is a new opinion from the Fifth Circuit dated July 17, 2013, and you can read this full opinion on the Fifth Circuit website. It's a case involving Asadi versus GE Energy. And the first thing you need to know that, of course, in the federal and state judicial system, opinions, trials, they're all public records. So in this case, plaintiff Khalid Asadi filed a complaint against General Electric claiming that the Dodd Frank Wall Street Reform and Consumer Protection Act, or the Whistleblower Act, had been violated. And now the district court granted General Electric's motion to dismiss for failure to state a claim. Basically, the district court reviewed the facts and said Mr. Asadi did not have a cause of action under that act and was not a whistleblower as defined by that act. So let's take a look at this opinion. In 2006, Asadi accepted General Electric's offer to serve as an Iraq country executive and relocated to Amman, Jordan. At a meeting in 2010, while serving in that capacity, Iraqi officials informed Asadi of their concern that GE Energy hired a woman closely associated with a senior Iraqi official to curry favor with that official in negotiating a lucrative joint venture agreement. Asadi concerned that this alleged conduct violated the Foreign Corrupt Practices Act, which basically says you're not supposed to bribe or foreign officials, reported the issue to his supervisor and to the GE Energy ombudsperson for the region. Shortly following these internal reports, Asadi received a negative performance eval, and approximately 1 year later he got fired. He's basically claiming that General Electric violated Dodd Frank whistleblower provisions by terminating him by following his internal reports of the possible Foreign Corrupt Practices Act violation. Now, General Electric moved to dismiss the claim, saying that he failed to state a claim because basically he didn't qualify as a whistleblower because he did not report a violation to the Securities and Exchange Commission. Now, the trial court ruled against Mr. Asadi, and now the Fifth Circuit's taking a look at it. They give a brief description of what the Dodd Frank Act is about. That Congress enacted Dodd Frank in the wake of the 2008 financial crisis. Section 922 of Dodd Frank encourages individuals to provide information relating to a violation of U.S. securities laws to the Securities and Exchange Commission. And this law encourages such disclosures through two related provisions that, one, require the SEC to pay significant monetary rewards to individuals who provide the information to the SEC that leads to a successful enforcement action, and two, which is involved in this case, creates a private cause of action for certain individuals against employees who retaliate against them. In other words, if you report something to the Securities and Exchange Commission, and if you're retaliated against, you can sue. So the basic question in this, it's right down here. We must answer this question: whether an individual is not a whistleblower under the statutory definition may in some situations seek relief under the Whistleblower Protection Act. They hold that the Dodd Frank Whistleblower Protection Act creates a private cause of action only for individuals who provide information relative to a violation of the securities laws to the Securities and Exchange Commission. Because Mr. Asadi failed to do so, his whistleblower protection claim fails. Now you need to go further down this decision for an interesting comment. They cite three provisions in the Act that gives protection. 1, in providing information to the Commission. 2, in testifying or assisting the Commission. Or 3, in making disclosures that are required or protected under the Sarbanes-Oxley Act, the Securities Exchange Act of 1934, or any law, rule, or regulation. They reiterate here that under Dodd Frank's plain language and structure, there's only one category of whistleblowers: individuals who provide information relative to securities law violation to the Securities and Exchange Commission. They claim that this provision is unambiguous. Now here they begin to look at third category. Importantly, the third category of protective activity has effect even when we construe the protection from retaliation of Dodd Frank to apply only to individuals who qualify as whistleblowers under the statutory definition. Now what's unusual in this opinion is on page 12. It's very unusual for a court to give examples, and that's exactly what they do. And they're looking at that third category. An example illustrates the effect of this third category of protective activity for whistleblowers. Assuming a mid-level manager discovers a securities law violation. On the day he makes his discovery, he immediately reports the securities law violation to his company's chief executive officer and to the SEC. So he's reporting it to the Securities and Exchange Commission, but he's also reporting it to his company. Unfortunately for the mid-level manager, the CEO, the chief executive officer, is not even aware that the person reported it to the SEC, but he fires the guy. The mid-level manager is clearly a whistleblower, as defined in Dodd Frank, because he provided information to the SEC. But it would be difficult for him to prove, and he'd be unable to prove that he was retaliated against because of his report to the SEC, because the company didn't even know about it. Accordingly, they say the first and second category of protective activity would not help him. But they say the third category of protective activity, the third clause, does protect the mid-level manager. In this scenario, the internal disclosure to the CEO, a person with supervisory authority over the mid-level manager, is protected under the anti-retaliatory provisions. Accordingly, even though the CEO was not aware of the report at the time he terminated the mid-level manager, the mid-level manager can state a claim under the Dodd Frank whistleblower protection because he was a whistleblower and suffered retaliation based on his disclosures to the CEO, which was protected under SOX. So, if you report to the Securities and Exchange Commission and your company doesn't even know about it, but then you also tell your company what they're doing is wrong, and they let you go, this Fifth Circuit opinion says you can sue the company for retaliation. And it's very unusual for a court or the Fifth Circuit to actually give examples. This is an example that companies and businesses certainly need to be aware of. In this case, we conclude that the plain language limits protections of the Dodd Frank whistleblower provision, and they affirm the district court's dismissal of the Asadi's Dodd Frank whistleblower protection claim.